This is part 7 of company law problems and solutions, and the topic first we are going to discuss here is shares. DJA Company Limited wants to provide financial assistance to its employees to enable them to subscribe for certain number of fully paid shares. Considering the provisions of the Companies Act, what advice you would give to the company in this regard? So, Section 67 of the Companies Act allows making of loan by a company to its bona fide employees for purchasing or subscribing to the fully paid shares of the company. However, subsection 3 provides that such financial assistance should not exceed 6-month wages or salary of the employee. Now, the next problem. A. The secretary of a company issue a certificate in favor of B by forging the signature of 2 directors. He also affixes the seal of the company on the certificate without authority. Can B hold the company liable for the shares covered by the share certificate? Give reasons. So this case we have already discussed under exceptions of indoor management, that indoor management deals with regularizing irregularities but not illegalities. So the same case law is used here. Reuben versus Great Fingal Consolidated. Transaction involving forgery are void ab initio, null and void, since it is not the case of the absence of free consent. It is a situation of no consent at all. This has been established in the Reuben versus Great Fingal Consolidated case. A person was issued a share certificate with common seal of the company. The signatures of 2 directors and the secretary was required for a valid certificate. The secretary signed the certificate in his name and also forged the signature of the 2 directors. The holder contended that he was not aware of the forgery and he is not required to look into it. The court held that the company is not liable for forgery done by its officers. Now another question. At a meeting of the 2 directors of a private company, one director refuses but the other agrees to approve a duly completed form of transfer of shares in the company from an existing shareholder to a third person. Explain the legal position of the proposed transferee of the shares. Now here, the transferee may appeal to the tribunal against the refusal within a period of 30 days from the date of receipt of the notice, or in case no notice has been sent by the company within a period of 60 days from the date on which the instrument of transfer or the intimation of transmission, as the case may be, was delivered to the company. Transfer of shares. The securities in a public company shall be freely transferable. Shares of a company are movable property and can be transferred by the shareholders in a manner prescribed by the articles. Right to transfer shares is absolute and inherent in the ownership of shares. Articles cannot absolutely take away the rights of members to transfer shares, thus making shares non-transferable. Shares of a public company are freely transferable, whereas a private company is required to restrict the right of the members to transfer the shares. The Articles of Association of private companies contain the kind of restriction on the transferability of shares. Generally, the restriction put by a private company is that of preemption, whereby the members are required to offer their shares first to the existing members of the company before offering them to outsiders. That is, the restriction put by a private company is that of preemption. That is, the existing shareholders are given a priority, and if they don't take it, then the outsiders are offered with the shares. Now, appeal against refusal. So, public company, that is section 58 subclause 4. The appeal may be filed before the tribunal. The transferee may appeal to the tribunal against the refusal within a period of 30 days from the date of receipt of notice, or in case no notice has been sent by the company within a period of 60 days in case of private company, and within a period of 90 days in the case of public company from the date on which the instrument of transfer or the intimation of transmission, as the case may be, was delivered to the company. Now, section 58 subclause 1. That is with respect to private company. Where a private company refuses to register a transfer, whether in pursuance of any power of the company under its articles or otherwise, it shall, within 30 days from the date on which the instrument or transfer was delivered to the company, send notice of refusal to the transferee and the transferor, giving reasons of such refusal. The tribunal, while dealing with an appeal, whether it relates to a private company or public company, may, after hearing the parties, either dismiss the appeal or by order A. direct the transfer of transmission shall be registered by the company, and the company shall, with such order, within a period of 10 days of receipt of the order, or the direct rectification of the register and also direct the company to pay damages, if any, sustained by any party aggrieved. So that is the relevant sections discussed here was section 58, the subclause 1 and subclause 4. So the transferability on the restrictions is different for public company and private company. The public company, there is no restriction, it is absolutely transferable. With respect to private company, some restrictions can be put in, and mostly it is preemption, the right of preemption. Now, next problem. A company refuses to register transfer of share made by Mr. X to Mr. Y. The company does not even send a notice of refusal to Mr. X or Mr. Y, respectively, within the prescribed period. Has the aggrieved party any right against the company for such refusal? Advice as per the provisions of the Companies Act 2013. Now, in case of a refusal by a company to transfer the shares, the company is required to send notice of refusal to the transferor and the transferee within 30 days of the receipt of transfer deed. Mr. Y is entitled to file an appeal to the tribunal against the refusal of the company to transfer the shares, and Mr. X has no right to appeal against the refusal of the company to transfer the share. So the problem was a company refuses to register transfer of shares made by X to Y. So here Y is entitled to file an appeal to the tribunal against the refusal of the company to transfer the shares, and Mr. X has no right to appeal against the refusal of the company to transfer the shares. Now, the next problem. Ramlal is a shareholder of a company holding 100 shares. Ramlal dies, leaving Mohan as his legal representative. Mohan is not a member of the company. Mohan transfers all 100 shares of the deceased member to Anil. Is the transfer valid? State reasons for your answer. Now here in this case, the transfer is not valid. Mohan can effect valid transfer only after the succession in his favor is duly registered with the company. Till then, the shares do not vest in him, and therefore he has no right to transfer the same. Now with this, we have to discuss about succession certificate. Where respondent had furnished succession certificate as well as transfer deed executed in their favor, they were clearly entitled to have rectification made by getting shares registered in their favor. And this was held in Jai Mahal Hotels Private Limited versus Rajkumar Devraj. So, this was held in Jai Mahal Hotels Private Limited versus Rajkumar Devraj. That is where respondent furnished the succession certificate as well as the transfer deed executed in their favor. They were clearly entitled to have rectification made by getting shares registered in their favor. Now the next problem is that Wasim and Hamid each held half the issued share capital of a company, whose articles of association provide this: the board of directors may at any time in their absolute and uncontrolled discretion refuse to register any transfer of shares. So this was there in the articles of association. Now Wasim died and his executor applied to have Wasim's shares registered in his name. The board of directors refused to register the transfer of shares under the above mentioned provision of articles of association. State with reasons whether the court can come to the rescue of Wasim's executor. So here this provision of articles of association is invalid. Section 58 disallows a company to reject registration of transfer of shares without assigning any reason. A company therefore cannot empower itself with a blanket power of refusal. Refusal is permitted only on specific ground as stated in articles. Now, forfeiture of shares. Directors of a company forfeit fully paid shares of B to recover some amount due from B. The articles of association of the company provide for forfeiture of shares in such a case. The shares are resold at a much higher amount than the amount due from B, and the company retains the excess as provided in the article. Advice B. Forfeiture is valid. The excess money realized must be paid to B. So with the provisions of the Act, where some amount of money is due from B, the directors can forfeiture the shares, fully paid shares of B. But since it was resold in a much higher amount than what is owed by B, the excess money shall be realized to B. It should be given to B. Now, forfeiture of shares. Forfeiture is withdrawal of shares due to non-payment of any call by the shareholder or of any other ground as may be provided in the articles. On forfeiture of shares, the member loses the amount paid thereon and his interest in the ownership of the shares. The power to forfeit shares must be expressly given in the company's articles. It cannot be implied. In order that the forfeiture of shares is valid, the procedure expressly prescribed by the articles must be strictly adhered to. The technicalities must be strictly complied with, as even a little inaccuracy may be as fatal as the greatest one. Even the whole body of shareholders or creditors cannot ratify a defective forfeiture. So, the technicalities must be strictly complied with, as even a little inaccuracy may be as fatal as the greatest one. Even the whole body of the shareholders or creditors cannot ratify a defective forfeiture. Now, reissue of forfeited shares. Forfeited shares can be either cancelled by the company or reissued. These can be reissued at any price, premium, par value or discount. But the amount of discount on the reissue of forfeited shares cannot exceed the amount forfeited on these shares. The purchaser of forfeited shares will acquire good title to the shares reissued to him. His title to the shares shall not be affected by any irregularity or invalidity in the proceeding in reference to the forfeiture and sale of the share. The Board of Directors is required to pass a resolution of the Board for reissuing these shares. Reissue of forfeited share is not an allotment of fresh share but resale of old shares, and therefore the company is not required to file any return of allotment with registrar regarding these shares. Forfeiture once made is conclusive and irrevocable and sever all connection between the company and its shareholder. An illegal forfeiture cannot be validated by lapse of time or acquiescence. In the case of wrong forfeiture of shares, the shareholder can bring action for setting aside of such forfeiture. If, however, it is possible on account of resale of forfeited share, he can sue the company for damages. The next is about membership. State with reasons whether the following can become members of a company. The first one is a foreigner, the second a partnership, third a company, fourth a Hindu undivided family. So to the solution. As per Indian Contract Act, a foreigner can enter into contracts and therefore can purchase shares in a company, but this is subject to the provisions of FEMA, that is Foreign Exchange Management Act 1999. So, as per Indian Contract Act, a foreigner can enter into contract and therefore can purchase shares in a company, but this is subject to the provisions of FEMA, that is Foreign Exchange Management Act. Now, with respect to partnership firm, a partnership firm being an unincorporated association and therefore not having a separate legal entity from the partners cannot be registered as member in a register of members of a company. Partners, either individually or in their joint names as joint members, may hold shares in a company as a part of the partnership property, but a partnership firm may become a member of a company registered under Section 8, that is Association Not for Profit of the Companies Act. So, a partnership firm may become a member of a company registered under Section 8 of Companies Act 2013. So, Section 8 of Companies Act 2013 discuss about association not for profit. Now, with respect to a company being a juristic person and a separate legal entity may become a member of another company that is subject to the provisions of Section 19 and Section 186 if it is so authorized by its memorandum to purchase or invest in shares. So, a company is a juristic person and a separate legal entity. So it can become a member of another company. So a company can become a member of another company if it is so authorized by its memorandum to purchase or invest in shares. And this is subject to the provisions of Section 19 and Section 186 of Companies Act 2013. Now, Hindu Undivided Family or HUF can be a shareholder of a company through the name of the Karta. So, HUF can be a shareholder of a company through the name of the Karta. Now, the next topic is minor member. A company issued 20 partly paid equity shares and registered them in the name of a minor, describing him as minor. The father of the minor signed the application on the minor's behalf. After some time, company went into liquidation. The company filed a suit against the father of the minor to recover the remaining amount on shares. Whether the company will succeed, advice. So here, the company cannot recover unpaid calls on shares from the minor, since the allotment of partly paid shares to a minor does not bind him to pay the unpaid calls. If the shares are allotted to the minor in response to his application and this name entered on the register of members in ignorance of the fact of minority, the company can repudiate the allotment and remove his name from the register on coming to know of the minority of the member. The company must repay all money received from him in respect of the allotted shares. The minor can also repudiate the allotment during his minority, and he shall be returned the amount he paid towards the allotment of shares. If the name of the minor continues on the register of members and neither party repudiates the allotment, the minor does not incur any liability on the shares during minority. There is no legal bar to a minor becoming a member of the company by acquiring shares or by way of transfer, provided the shares are fully paid up and no further obligation or liability is attached to them. So that was discussed or decided in Devan Singh versus Minerva Films Limited. In Devan Singh versus Minerva Films Limited, the court held there is no legal bar to a minor becoming a member of a company by acquiring shares or by way of transfer, provided the shares are fully paid up and no further obligation or liability is attached to them. The next problem we have is Honest Cycles Limited has received an application for transfer of 1000 equity shares of rupees 10 each. So once again, Honest Cycles Limited has received an application of transfer of 1000 equity shares of rupees 10 each, fully paid up in favor of Balak. On scrutiny of the application form, it was found that the applicant is minor. Advise the company regarding the contractual liability of a minor and whether shares can be allotted to Balak by way of transfer. The company is advised to transfer fully paid shares to Mr. Balak. In case of transfer of partly paid shares to a minor, the company may refuse to register him as member. In case the company, in ignorance of the minority, has permitted the transfer, then the company may remove the name of the minor and replace it by that of transferor, even though the latter may have been ignorant of the minority. But when it is a case of fully paid and there is no liability that comes on the minor, the company can transfer the fully paid shares to the minor. And that was also held in Devan Singh versus Minerva Films Limited. That is, if the shares are fully paid and no further obligation or liabilities attached to the minor, then the minor can be a member of the company. So that was held in Devan Singh versus Minerva Films Limited. Now the next one is joint membership. A, B, C hold jointly 100 shares in a company. They want the order of names changed in their share certificate as B, A and C, and make an application for change and lodge the original share certificate. The company direct them to execute a proper instrument of transfer to effect the change. Is the company justified? Solution. A request signed by all the holders in the existing order and also proposed order is sufficient, which the board of directors can consider and effect transposition of names. In case of joint shareholdings, One or more of them may require the company to alter or rearrange the serial order of their names in the register of members of the company. In this purpose, there will be need for effecting consequential change in the share certificate issued to them. Since no transfer of any interest in the shares takes place on such transposition, the question of insisting on filing transfer deed with the company may not arise. Now, borrowing powers. Gomez, the chairman of a company, borrowed 5 lakh from the State Bank of India, Patna. Under a promissory note. A suit was filed for the recovery of debt on the basis of the promissory note executed by the chairman. The company refused to accept the liability on the plea that the chairman had borrowed funds without authorization from the company. Will the company succeed? Explain. Here, there is a case law, that is Krishna Kumar Rohatgi versus State Bank of India. Krishna Kumar Rohatgi versus State Bank of India. A sum of 5 lakh was advanced to the defendant company by a bank. The company executed a promissory note in favor of the bank. It renewed the promissory note from time to time and made payment towards the amount advanced to it. In June of 1959, a promissory note was renewed by managing director of the company. The loan amount, however, was not paid, and the bank ultimately filed a money suit. The defense of the company was the managing director, in the absence of a resolution adopted by the board, MD had no authority to execute a promissory note. Therefore, the loan was not binding on the company. In the suit for the recovery, the company contended that the promissory note was executed by the chairman without board resolution authorizing him to execute the promissory note as required under section 179, subclause 3, subclause D. The Patna High Court held, if the loan amount, even taken without its authorization, had been used for the benefit of the company, then the company cannot repudiate its liability to repay. Once again, the Patna High Court held, if the loan amount, even taken without its authorization, had been used for the benefit of the company, then the company cannot repudiate its liability to repay. When an agent borrows money for a principal without the authority of the principal, but the principal takes benefit of the money so borrowed, or when the money so borrowed have gone into the coffers of the principal, the law implies a promise to repay. So that was held in Krishna Kumar Rohatgi versus State Bank of India. Now the next topic is shareholders meeting. A meeting was properly convened and was subsequently adjourned by the chairman because quorum was not present. No fresh notice is given for the adjourned meeting, which is held subsequently. State whether the adjourned meeting is valid. So according to section 103 of the Companies Act 2013, once again section 103 of Companies Act 2013, if within half an hour from the time appointed for holding a meeting of the company, a quorum is not present, the meeting shall stand adjourned to the same day in the next week at the same time and place, unless the director determine otherwise. No fresh notice is therefore required to hold the adjourned meeting in case the same is held on the same day next week at the same time and place. But in case of a change of day, time or place of meeting, the company shall give not less than 3 days notice to members, either individually or by publishing an advertisement in the newspaper, one in English and one in vernacular language, which is circulated at the place where the registered office of the company is situated. And the next problem, in a general meeting of shareholders, a special resolution was put to vote. 90 voted in favor, 20 voted against, and 40 abstained. Has the resolution been validly passed? So 90 voted in favor, 20 voted against, 40 abstained. Yes, votes cast in favor are 3 times of the votes cast against it. So this resolution been validly passed. Now the next problem. The board of directors of a company do not expect that the final audited account of the company would be ready to be circulated amongst the company's members in time. But if they do not convene the annual general meeting in due time, the retiring directors would be deemed to have retired on the date on which the annual general meeting ought to have been held. What advice do you give in such a situation? So the solution is that the company should apply for extension of time for holding the meeting to the registrar. The company can make an application towards the registrar stating the reasons why there should be an extension of time for holding the meeting. Now the next problem is, the Articles of Association of a company provides for holding its annual general meeting at shorter than 21 days notice, provided the consent of all the shareholders is received. Will the holding of the annual general meeting at a shorter notice be valid in the following case? And two scenarios are given. The first one, if the consent of the shareholders for the short notice is received orally. And the second one, if the consent in writing is obtained at the meeting itself. Now the solution, in case all members entitled to vote at the meeting agree, shorter notice is valid. The consent may be obtained in writing before the meeting or by a resolution at the meeting itself. The next problem, A member of a company gave a proxy to B, in pursuance of which B attended the meeting of the company after satisfying all the requirements of law. However, A himself attended the meeting and voted on a particular resolution. A's vote was rejected. Discuss the validity of A's vote. Now here, the rejection of A's vote was not valid. Proxy can exercise his vote only in a case where the shareholder has elected not to cast his vote in person. Where he decides to exercise his voting right personally, he eliminates completely the necessity of proxy being exercised at all. Now, appointment and rights of proxy. The law entitles every member of a company to appoint a person as his proxy to attend and vote at the company meeting instead of himself, that is by section 105 subclause 1, section 105. So, however, a member of the company having no share capital does not have this right unless its articles provide expressly. Now, section 105 also discusses that. Okay, we have about 8 clauses in section 105. The second clause, a member of private company is not entitled to appoint more than one proxy to attend on the same occasion unless its articles provide otherwise. But a member of a public company may appoint more than one proxy. That is, he may appoint one proxy in respect of certain shares held by him and a different proxy for other shares held by him, provided that a person appointed as proxy shall act on behalf of such member or members not exceeding 50 and any such number of shares as prescribed. So maximum limit of shares is 50 or any such number of shares prescribed. So they cannot be more than 50. Provided that a person appointed as proxy shall act on behalf of such member or members not exceeding 50. And the number of shares may be prescribed by the Act or by the central government from time to time. Now, any person can be appointed as a proxy. That is the third clause. Any person can be appointed as a proxy, whether he is a member of the company or not. In case the proxy is not a member of the company, he shall have no right to speak at the general meeting unless the articles otherwise provide. However, a proxy may put questions in writing and send the same to the chairman for answer. Now, the fourth clause. All these clauses are under section 105. The fourth clause, a proxy is ordinarily entitled to vote only on a poll, but he may vote on voting by show of hand if the articles provide. Besides that, he may demand or join in demanding a poll. However, he shall have no right to inspect proxy forms or the minutes of the meeting. Now, clause 5. Proxy must be appointed by an instrument in writing, duly stamped and signed by the member of the company. A blank but stamped proxy is valid but may be completed by the person authorized to do so. Proxy must be deposited with the company at least 48 hours before the commencement of the meeting. A company, however, cannot legally require proxies to be deposited with it earlier than 48 hours before the time of meeting. After giving 3 days notice to the company, members may inspect during business hours to proxies lodged with the company at any time during the period commencing 24 hours before the time for the commencement of the meeting and ending with the conclusion of the meeting. So, with 24 hours prior to the meeting and ending with the conclusion of the meeting. The other members can also check the forms of proxy. Proxy launched for the original meeting remains valid for adjournment meeting also, or the adjourned meeting also. Now the sixth clause, every notice of a meeting must appropriately mention that a member is entitled to appoint a proxy and that the proxy need not be a member. A company cannot send invitation to members to appoint any one or more persons as proxies. Now the seventh clause, a proxy is revocable. It can be revoked at any time. Death of the member appointing a proxy will, in the absence of provisions in the articles, revoke the authority of the proxy. Member may himself attend and vote in the meeting. Vote tendered by the proxy in such a case will not be accepted because the need of exercising the proxy had never arisen. Proxy in this case shall stand revoked impliedly. However, the mere presence of a member at the meeting does not imply the revocation of the authority of the proxy. When both the member and the proxy are present at the meeting, the member's absence from voting on the resolution on which the proxy cast his vote does not imply the revocation of the authority of the proxy. A proxy appointed later revokes the proxy appointed earlier. And the eighth clause, the relationship between the member and the proxy is that of a principal and agent. A minor member who has no capacity to appoint a proxy. He can act only through his guardian. However, a minor can be appointed as a proxy. In the case of a joint holders of shares, proxy appointed by the first named joint holder will have precedence over the proxy appointed by the second joint holder. So, in the case of the joint holders of shares, proxy appointed by the first named joint holder will have the precedence over the proxy appointed by the second joint holder. Proxy appointed by the first joint holder will exercise voting right to the exclusion of the joint holder who may be present in the meeting. Now, the next problem, that is, how would you deal with the appointment of a representative or a proxy at a general meeting of the company and exercising the rights of a proxy in the following case? The scenario 1 is when a body corporate is a member in the company which has called a general meeting. That is, the first scenario is when a body corporate is a member in the company which has called a general meeting. And the second scenario is when a foreign company is a member in the company. So, the relevant section here is section 103 says that a body corporate, whether a company within the meaning of this act or not, may, by resolution of its board of directors or other governing body, authorize such person as it thinks fit to act as its representative at any meeting of the company or at any meeting of any class of members of the company. So, earlier we discussed proxy with respect to section 105 and this is section 103, which we discuss about proxy by a body corporate. A person authorized by resolution as aforesaid shall be entitled to exercise the same right and powers, including the right to vote by proxy on behalf of the body corporate which he represents, and that body could exercise if it were individual member or creditor of the company. Now, the next one is the chairman at an annual general meeting declares a motion carried after show of hands and says 10 in favor, 15 against it, but 60 voting in favor by proxy. Is he right in his judgment? The chairman is not right in his judgment. Proxies are not entitled to vote in case of a voting by show of hand unless the articles of the company otherwise provide. The votes cast in favor of the motion are less than votes cast against it, and therefore the motion should be taken as lost. So once again, 10 in favor, 15 against, but 60 voting in favor by proxy. So unless the articles provide for it, the proxies cannot vote by show of hands. So we are considering 10 for and 15 against. So the resolution stands as lost. The next problem, a proxy was appointed by a member on an instrument duly executed. will the vote cast by proxy be valid in the following cases? The first scenario is when the member himself attended and cast his vote at the meeting without revoking the authority of the proxy. And the second scenario is when the member died in the meantime. So we have two situations here. One is when the member himself attended and cast his vote at the meeting without revoking the authority of the proxy, and the second one when the member died in the meantime. So the solution: the proxy stands revoked if the member attends the meeting personally. Thus, in this problem, the vote given by the proxy will not be valid. And this is also laid down by the court in Cousins versus International Bricks Co. Limited. That is Cousins versus International Bricks Co. Limited. But the revocation should be communicated before the meeting. Revocation will be too late if the communicated after the meeting has commenced. In such a case, the votes cast by the proxy will be valid in a poll. And that was held in Spiller versus Mayo Rodenstina Development Company Limited. So, we have two case laws with relevant to the first scenario, that is member himself attended and cast his vote at the meeting without revoking the authority of proxy. So in that we have two relevant case laws. One is Cousins versus International Bricks Co. Limited. In that case, it says that proxy stands revoked if the member attends the meeting personally. Thus, the vote given by the proxy will not be valid. That is held in Cousins versus International Bricks Co. Limited. Whereas in Spiller versus Mayo Rodestina Development Company Limited, Spiller versus Mayo Rodestina Development Company Limited, it was held that the revocation should be communicated before the meeting. Revocation will be too late if communicated after the meeting has commenced. In such a case, the votes cast by the proxy will be valid in a poll. So that are the two relevant case laws with the first scenario, that is where the member himself attended and cast his vote without revocating the authority of the proxy. And the second scenario where the member died in the meantime. The vote cast by the proxy shall be invalid if the member appointing the proxy dies and the company comes to know the death of the member before the commencement of the meeting. So here the elements are the member who appointed the proxy dies and the company has to know about it before the meeting commences. So both has to be satisfied. Then if the company has no notice of such death, the vote cast by the proxy shall be valid. Now the next problem, that is A appoints B as proxy. Just before the meeting, A comes to attend the meeting. Explain the position of proxy appointed by A. So here the case law Cousins versus International Bricks Limited can be brought relevant or attracted. If the shareholder after appointing the proxy himself attends the meeting, he can vote in person. The proxy stands revoked. Now we have another problem, that is a non-member of XYZ Limited had been appointed as a director of the company. Later on, he became chairman of the company. In the annual general meeting of XYZ Limited, A presided over the meeting. Z, a member of the company, objected to his chairmanship on the ground that A is not a member of the company. Discuss the validity of Z's claim. The solution: since a director need not be a member of the company unless articles otherwise provide, a non-member may well be a chairman. Objection of Z may therefore be not sustainable. So it depends on the articles of the association or articles of the company. So that is with part 7 of company law problems and solution, and the problems are still a lot more pending, and those will be covered in the following parts or following sessions. Thank you for listening and stay tuned.